Of the star of the movie, the main character in the book, going before the grand jury. I'm going to start by posing the question to our prosecutors. What goes into your consideration for charging? I'll start with an average individual, but then I want you to talk some about what goes into a decision about whether to charge a police officer.
Usually the decision.
Thank you.
Usually the decision to seek an indictment, which would put you into the grand jury process, would start with some initiation of criminal process at our lower court level. And what starts that usually will be an arrest. And that arrest, at least in North Carolina, will be made by law enforcement. It comes in the form of a warrant. Everybody knows what a warrant is, or a criminal summons. Those two things are only good for you in your district court, and they don't even get to this grand jury part. It takes a district attorney seeking an indictment in our superior court before a grand jury in order to get to this point. In doing that, we will typically, whatever officer or unit of law enforcement that made the arrest or sought the summons, we will then send that person to talk to the grand jury about the case. And so in the state system, we never ask a witness or civilian to go before that grand jury. It's always going to be the law enforcement officer who gives the summary and rundown of exactly what their investigation, what the results of their investigation. Again, the grand jury at that point gives sort of an up or down. If I, in reviewing that warrant and summons, do not believe that this is something that merits that should be, for which we should seek an indictment, we don't. If I believe that we do, then I will submit that for an indictment. What I want to say, and I think this will be applicable not only to police-involved cases, but also any type of case, is that even after an indictment is sought and secured, it is still incumbent on a prosecutor to decide whether or not they will go forward. Which is to say that if the investigation is ongoing even after the indictment has already been secured, if there is new information that comes to light in any case, which suggests that we should not be going forward and cannot meet our burden, our ultimate burden of proving a case beyond a reasonable doubt, it's the prosecutor's responsibility not to proceed in that case, despite what a grand jury says.
Mr. Smith?
In the federal system, if you're talking about a police officer or law enforcement, those cases typically would be with a local U.S. Attorney's Office working with someone from the Civil Rights Division, which oversees these cases. Unlike the state system, you can have grand jury processes just to investigate, even if you don't make a decision, have not made a decision yet necessarily to prosecute. And in the federal system, typically it is because a law enforcement officer has violated the constitutional rights of an individual. And also in our grand jury, the federal grand jury, in addition to law enforcement officers, we would call pretty much all civilians, pretty much everybody who had knows a little bit about the facts of the case. And then, as Mr. Merriweather said, after reviewing all the evidence, make a decision to go forward and seek an indictment. But typically, that would be the grand jury process of a case involving a law enforcement officer.
So I'm curious of our two young ladies, Kelsey and Kendi. You may more closely identify with Star as she was being depicted, both in the opening clip and the one we just saw. Do you have any reactions to the way she was able to present her side of the story?
Go first?
No, you got it.
For me, being in a situation like that as a young driver, that's probably one of the most nerve-wracking things for me. I feel like she presented herself in the right way. She presented her perspective of what she thought of who Khalil was. She also portrayed him differently as probably the media will look at him. They probably saw a unarmed black man as, oh, he's probably acting like a thug, he was this and that. She's like, no, I know him. I've known him since we were little kids. He's not like that. I feel like she did the right thing. She presented him in the way that, of the true person that he really is.
Can I add?
Now for our two young men. Okay, let me ask our panelists, just keep the microphone out, because we're going to keep asking back.
Okay. Well, one thing I liked about how she presented herself was she kept on saying Khalil's name over and over and over. So that's like a tactic most people do, because we always get the stories about how somebody's getting shot, and it's today, and then tomorrow you don't remember it. But she kept saying his name over and over so you wouldn't forget who he was and what he was about. And that was just the main thing that I thought was really strong about her speech.
Don't give it away. Don't give the microphone away. So for the two young men, I was going to ask if you've ever been stopped by the police and how you felt that interaction.
Absolutely. So it's interesting because so I just became an alpha. I'm a brother Alpha Fraternity Incorporated, and I got accepted into UNC Chapel Hill Law School. And the day I got accepted into Chapel Hill Law School, I went out to dinner with a group of my guy friends. And left, I'm excited, I'm like, I'm about to start my legal profession, and get to the spot where many of these gentlemen are already at. So I'm coming home, and I'm driving faster than I should. I won't say how fast I was driving. But I'm going faster than I should. And so I'm going, and I see an officer parked in front of a dentist's office. And immediately, I tried to stop. Obviously, it didn't work because he pulled straight out behind me. And I'm not sure if it's like officers' lights are like delayed in a sense. But when it didn't turn on, I was like, okay, well, maybe he's not stopping me, but then they turned on. I was like, I'm caught. So I pulled over to a gas station in a bright, lit area. And the first thing that went through my mind was just keep your hands on the steering wheel, at all times. Because I've heard stories. Prior to that, I was never really afraid of anything happening to me, but I am mindful of the fact that it can happen to anybody. So I kept my hand on the steering wheel. The officer was very respectful. He told me how fast I was going. He gave me my ticket, and then it kind of went on from there. So
Without incident.
Without incident, which I was excited about, because because prior to that, I never got stopped. I never had interaction with the law prior to that ticket. So getting that ticket was, one, it was a wake-up call to stop speeding. And two, it was, as a young black man, being put over in that position, knowing the history of America and the history of African-American men who were stopped. Whether it's Alton Sterling or, other black men who've been in a position where they didn't make it home, right? Both parties fear for their lives, whether you're an officer, because you have a family as well, or whether you're an African-American male who seeks to continue on with your life and advance yourself. So, just watching this movie and learning about Star and Khalil and having, seeing how Star was a character witness for Khalil. I can imagine if she would stay silent throughout the movie, if she wouldn't have spoke on Khalil's behalf. Because life, a lot of times, is about a narrative battle. There's a narrative for law enforcement, and there's a narrative for minority communities. And these narratives often get lost because there's so much tension in the process. Everybody's so heated about what is going on. Not too long back, there were protests in Charlotte. I call them protests, but you'll come across people who call them riots, right? So language is important. How do you go about telling these stories? So.
You've raised a lot of issues, and I'm going to try to unpack some of them. For our defense attorneys, Mr. Ferguson and Mr. Hill, can you share with the audience any experiences you have had or that you're aware of defending, well, not really defending, but involved in police misconduct cases?
Well, I'll give you two. I want to give you one from years ago, 1967, when I first started practicing law. And then I'll give you one from last year that I've been involved in that I think are important. In 1967, here in Charlotte, there was a young black man who was commonly known as Little Wolf, who was killed in Freedom Park by a white police officer. There were no witnesses to the event. The officer claimed that Little Wolf threatened him with a knife. Little Wolf was known to hang out in the park. He'd never been violent and had no reputation for violating the law. But in this instance, where the officer claimed, for whatever reason, that Little Wolf threatened his life and shot and killed Little Wolf, we were left with really one witness. There were some other officers there, but it was the officers. And their word was all that we had. So in trying to get justice for Little Wolf, I had very little to work with. And even if there had been witnesses, and the witnesses had been friends of Little Wolf, people who hung out in the park, black, I still wouldn't have had much to work with. And I saw case after case over the years where the officer's word against the word of someone that they had violated and who survived, still the officer's word was like gold. And a white officer testifying against a black witness or a black defendant, the outcome was usually predictable. Now I want to fast forward to last year in my hometown in Asheville. A young black man on his way home from we worked at I think Cracker Barrel and McDonald's, some relative fast food place. Going home at 11 o'clock at night after he got home, was accosted by two white officers. And he was tased, shot with a taser a couple of times. He was beaten in the head and then charged with assault on an officer as resisting arrest. When asked why he was stopped to begin with, the white officer said that he stopped him because he was jaywalking. Bear in mind, this was around midnight in Asheville. There was nobody much on the street. But the saving grace and the difference in 1967 and 2018 was that the officer was wearing a video cam and it was on. And so it didn't come down to the word of my client against the word of the officer, but modern technology gave us a third witness, which was the video cam. And the video cam showed, number one, that there was no jaywalking involved. The video cam also, and the officer also said that he beat and tased him because he was being attacked. Well, the video cam showed that my client was simply begging the officer to stop for the entire time that the officer was either beating him in the head with his blackjack or whatever you call it, or fist or whatever. So that made all the difference. And in this case, instead of my client being convicted of an offense because his word was no good against the officer's word, we wound up with all the charges against my client being dropped. And the officer, in fact, has been charged with assault. He was dismissed from the police force. All of that was unheard of 30, 40, 50 years ago, where you had nothing but the word of a white officer against a black witness or black defendant. So it made all the difference. And in fact, because of that, we were able to proceed against the officer civilly, to bring it, to threaten an action against the officer. And in this case, the city chose to resolve this case. And they paid my client $650,000 for the ordeal that he had been put through that night. And I mentioned that to contrast where we once were and where we are now. That's not to say that we're on an equal footing from a defense perspective, from a racial perspective, but there has been significant improvement over the years, and technology has made all of the difference. And we see that technology in a number of different instances where someone, a bystander, someone with a video camera, has captured an event where, but for that technology, the word of a white officer would have been taken over the word of a black victim or a black witness. So I'm thankful that we've come as far as we have. I'm also aware that we're nowhere close to where we need to be.
Mr. Hill, can you share some experiences or any difficulties you may have had in creating the narrative around the person who has been shot or assaulted?
Well, all of my experiences predated the iPhone. All of my professional experiences with 1983 cases, or even representing clients in this situation.
What's a 1983 case?
A civil rights violation. So that if you're the subject of what you think is disparate police treatment, either because of race, national origin, or gender, those sorts of things, you can file a 1983 action in federal court to uphold your civil rights. I'd like to talk a little bit about the power differential and the hostility that we often feel in the community. 20 years ago, I was going to a meeting at the law firm in Winston-Salem, a retreat. Didn't know Winston-Salem. There was an officer in a patrol car ahead of me. I shined my high beams, put on my blinkers, and approached the officer. He had his gun out. Held his gun at me all through my inquiry. I was looking for directions. And so when Starr talks about the gun being pointed at her, it's real, the trauma that imposes. Judge Diaz has a colleague on the D.C. Circuit, Robert Wilkins, who was a friend of mine in D.C., driving from a funeral for his grandfather. He's stopped, car's empty, guns pointed, and there's just racial profiling. He sued, got a pretty good judgment. My best friend from law school, midnight, she's wearing Daisy Dukes and a tank top, spread eagle on the asphalt, full felony stop. Shotguns, service revolvers. She was traumatized for years after that. I don't have a bad story on CMPD, mostly not because I'm sure there are bad stories, but sort of relative to Gaston County, Rowan County, Iredell County, there are a lot more of these bad stories outside of Mecklenburg. In Gaston County, there's a woman who fled from her car. She was prone, stopped, and she was shot in the neck. And the only reason we were able to bring that case free was because there was an illegal alien across the yard who saw what happened, and she was courageous enough to come forward and say what happened. She was from Costa Rica or one of the Central American countries, and she thought this was kind of routine. Folks in uniform shooting people. And she was here, and she stood up, and she testified. So part of what we're talking about is a culture in which law enforcement can be just brutally hostile to citizens. In Rowan County, one of our law partners had a series of lawsuits against the Salisbury police. It started with a woman who was watching a traffic stop right across the street from her home. And this is, again, before iPhones. So she had a mini camera. And she was taking pictures from her yard, from within her yard, of the police stop. And she was ordered to put the camera down. She kept running the film. The cop ran through the fence. She was going into her home, pulled her out of the home, arrested her for, obstruction, delay, and, and this was common before the iPhone. That if you were out, you saw what you thought was police misconduct, and you either said something or even attempted to record. Like Starr says, 115 is the officer's number to get ID information on officers. You then got pulled in. And it was always your word against the officer's word. I think that dynamic has changed some now because, almost universally people have cameras on their phones. And so citizen-police interactions are now much more readily recorded. And so I imagine, we're in a somewhat different position on many of these interactions. But I'm sure we'll get back to this point again. One of the things I feel certain about is that the criminal justice system is not the best way to treat officer-involved shootings. Trying folks with the criminal standard is a difficult one to do. And I think our system's challenged by how we deal with that.
I'm going to, speaking of those challenges, ask our prosecutors, Mr. Merriweather, I'll start with you. What kind of challenges do you face in getting witnesses to cooperate with you and come forward and testify, or at least be interviewed about what they saw or what they know?
So in North Carolina, we are a little bit unique in the sense that charging decisions usually do start with law enforcement. That is not true everywhere. Which is to say that sometimes, as Kenny mentioned, that there are other sort of investigative tools like a grand jury to go out and seek and subpoena and get information and then decide how to proceed. So typically the witnesses that we will have are ones that have been identified by law enforcement. Once they have been identified, yes, we will face challenges almost inevitably in locating them, in getting them to be a part of a justice process that, depending on who they are and what they've experienced, is likely has not treated them kindly, and we must confront that with them. And usually, when I was particularly a line prosecutor, I usually would tell people this is an opportunity, and you coming forth and offering the truth at making this system just a little bit better. At helping someone out there actually have a better chance at justice. But that means that you constantly have to be advocating on behalf of justice and reminding witnesses who and what you're actually fighting for. Because if they don't see that, if that's not apparent for them, if they have no faith in you, then they're not going to be a part of your process.
Can you force an uncooperative witness to testify?
We can force an uncooperative witness to take the stand or to come forward. There are certain circumstances by which they can claim a Fifth Amendment right against self-incrimination. Meaning if it looks like they're going to put themselves in some criminal jeopardy, that they can say, well, I'm not testifying, and we have to abide by that a lot of the times, most of the time, as a matter of fact. There are some exceptions, however. I can also tell you that one of the quickest ways to have someone all of a sudden change or forget what they saw is by forcing them to take the stand. And while a lot of people who find themselves as victims of crime would say, well, can't you do something to them about that? Usually not. We are sort of forced to deal with whatever we have, whatever sworn testimony is there. And it's very difficult to climb inside someone's head and make them recreate something, which is part of why it is so important about how you treat your witnesses, how you treat your victims, and what sort of faith you're giving them in the justice system. And, you know, I think the question is raised about what sort of protections can you offer to people within the justice system. And when you believe that there are reasons to, at least for a while anyway, conceal the identity of a witness through an investigation. I might find myself going before a judge and seeing if there is I can lay out some special circumstances for why this person needs special protections. If I'm working with law enforcement who has the capability of offering me external protections outside of our court system, that also can be done if the right circumstances are laid out. I hope that answers your question.
It does. Mr. Smith, we sometimes hear colloquially or on TV about the Witness Protection Program. Is it real?
Yes, ma'am, it is real. But I mean, that's a unique situation. That's a very, very important case. There is such a thing that is run by the United States Marshal Service that in certain cases where witnesses may, or their families may be at risk, you can enter the Witness Protection Program. But one thing I wanted to speak on briefly, and I don't know if Spencer feels the same way, and maybe one of the later questions, is you being a black prosecutor and you run into situations where you have either, typically I would say, law enforcement officers, primarily in rural counties, or sometimes even your colleagues who have a different sensibility than yours about cases. And it is admittedly sometimes a tough position to be in. I remember early on, I've been at the U.S. Attorney's Office 25 years. And there was one of my colleagues who was about to, from Charlotte, so he was prosecute a case out of, I think maybe Greertown, and 10 people in the conspiracy. And he wanted to throw somebody in who lived at this particular house. And this guy had never clean criminal record, he went every day, paid his bills. And my colleague was saying, well, he's in the house with those people selling drugs. He must know something. And I said, no, because I'm from Charlotte and I have relatives. I have relatives on both sides of the law. That's just how it is. If people are being honest. And so I just said, look, he just that's the best he can do. He's living with relatives. He's saving his money. But point of the matter is sometimes as a black prosecutor, you have to bring sensibilities and real world perspectives to other people. And I think sometimes even with police officers, they definitely, I won't say test your loyalty sometimes, but feel like, the whole blue line. If you're law enforcement, you're going to back us. And a lot of times it is my job to say, no, you have not done that right. And as Spencer said, we do have a mission, we do have a higher calling, and part of that higher calling, if we're going to prosecute, we have to do it right.
Judge Archie, can I just want to add something about this issue of stops, because Mr. Ferguson brought up a point about his client being stopped for jaywalking. I think a lot of people are often surprised by the authority that police officers have to make stops. I mean, there's a Supreme Court case that was decided some years ago that essentially says if a police officer suspects you of having committed virtually any violation, he's entitled to stop you and investigate that violation. And then if he thinks that you are armed and dangerous, he's entitled to frisk you as a result of that investigation. On my way over here, driving to the church, I imagine I might have committed 15 or 20 violations of the law. And could have been stopped for any one of those, right? And if you recall in the movie, Khalil, the ostensible reason why the officer gave for stopping him was because he crossed 3 lanes of traffic. And that was what started that whole tragic sequence. But that's what the law is. The law provides for police officers to objectively, and it doesn't matter what their subjective intent is, so long as it isn't illegal. They could be looking for a gun, they could be looking for drugs, but if they pull you over for a traffic stop, they can investigate that. Now, I grew up in New York City. In 2011, a class action lawsuit was filed against the city and the New York Police Department. From 2004 to 2012, the New York Police Department stopped over 4.8 million New Yorkers to investigate criminal offenses. Over 80% of those were black and Hispanic. 80%. A lawsuit was filed by the NAACP and a number of other plaintiffs alleging a violation of constitutional rights because of that. That lawsuit went on for about 4 or 5 years. The city challenged the findings of the district judge that found that there had been constitutional violations. But ultimately they settled and decided to move forward with the judge's recommended changes. So in 2011, the city had stopped 685,000 of its citizens. In 2017, as a result of the changes wrought by this lawsuit, the New York Police Department engaged in 10,000 stops, so a huge difference. And the city is no less safe. New York City is one of the safest cities in the country for its size. And so I think what it showed is that police officers can effectively police without engaging in oppressive and often illegal tactics. And so it's sort of a balance, right? Because we want police officers to engage, and we want police officers to protect us, but we want them to do it in a way that protects our individual civil liberties and our rights. And that's a fine balance, but it's a balance that we need to try to find each and every day.
And Judge, while you have the microphone, so in that scenario, there is this underlying element of perceived, perhaps real, racial profiling. And Mr. Hill spoke to that, some of the aggressiveness that officers use in identifying suspected crimes. How does that play out in front of you?
Well, there's no particular statute of law that bars racial profiling, but there are a number of statutes, and Mr. Hill talked about it, the 1983 Civil Rights Statute that allows a plaintiff to bring a lawsuit, such like the lawsuit that Mr. Ferguson described for a violation of civil rights. And that includes a violation of equal protection, that is that the plaintiff has been treated differently than others in his class, either because of race, gender, ethnicity, whatever the case may be. And in certain instances, the federal government can file a criminal prosecution against police officers. That's a separate statute that allows a federal criminal prosecutor to bring a criminal indictment against a police officer for willfully violating an individual's civil rights. And let me give you an example, a recent example of that I actually was involved in. And I'm going to tread carefully here because I don't want to get into all the details of the case, but it has been resolved, at least at our level, although I think it may end up going to the Supreme Court. I'm not sure about that. But many of you may remember Officer Michael Slager, of the North Charleston Police Department, who was accused of shooting Walter Scott in the back as Mr. Scott ran away following the traffic stop. And like some of the cases that some of the other folks have talked about, there was a video in that case shot by a bystander. Video, not all of the stop, but a good bit of it. And Mr. Scott had been pulled over for a traffic violation. And at some point, there was a tussle between Scott and Slager on the ground. And Slager pulled out his taser and tased Mr. Scott, at which point Mr. Scott got up and started running away. And Officer Slager pulled out his service revolver and shot him in the back. And that was shown on the videotape. He was indicted by a state jury in South Carolina, in North Charleston.